Hello and welcome to the Husch Blackwell Labor Law Insider Podcast. I'm Tom Godar, your host, and I'm glad that you've come along. In this podcast, we welcome guests with practical expertise and experience regarding labor law issues, and they share their insights related to this ever-changing area. The breadth of developments in laws related to unions and individual workers' rights that we are experiencing under the Biden-appointed National Labor Relations Board and led by General Counsel Jennifer Abruzzo is unprecedented. These developments demand that employers and those giving counsel to organizations stay tuned into these changes and make necessary adjustments to their practices and to policies. When President Biden was elected, he promised to have the most union-friendly administration ever, and he is fulfilling that pledge. So buckle up and hang on for this wild and wonderful ride in the world of labor law. It is so great to have you back with the Labor Law Insider. This is your host, Tom Godar, and once again, we're excited to talk about changes and developments that are based on the National Labor Relations Board and its decisions. We're going to talk about Lion Elastomers and the United Steelworkers decision that came down on May 1st. And we're going to have the pleasure of talking about it with my colleague and partner, Rufino Gaytán. Rufino has been a frequent guest, but if you don't know Rufino well, you may not realize that he's been recognized by best lawyers and by super lawyers. You may not know that he's a Badger, though he's now practicing in our Houston office for Husch Blackwell. You may not know that his practice goes beyond just labor law, but he's also considered by his clients particularly as an expert in EEOC and OSHA matters. He practices not only before the board, but he's had litigation experience for federal courts on a number of matters. And Rufino mostly is a good friend and a thought leader in this area. It's great to have you back with us, Rufino. Good morning.
Good morning. Thank you, Tom, for that wonderful introduction. And there was only a few lies in there, so thanks.
Well, we'll let the folks go to your webpage and find out which of those were lies. Hey, we talked about this. Gosh, you've been with us on Labor Law Insider podcast for, a couple of years. And one of our ongoing comments is that with the National Labor Relations Board as reformatted by President Biden and his administration, that it has leaned hard towards unions and employees. And that obviously the Trump board had gone another way. And before that, the Obama board had. In fact, we who practice in this area have become, resigned to the fact that, in a sense, that elections have consequences, but in a broader sense that a Democratic or Republican administration is likely to appoint members who are going to change precedent. And I'll tell you, the decision that we're talking about that came out on May 1st, the Lion Elastomers and United Steelworkers, is absolutely a piece of that ping-pong back and forth game, isn't it?
Yeah, absolutely. And unfortunately, for employers, I think what this case does is it creates additional uncertainty. It puts most employers who have to deal with these situations, which actually come up more often than they would like, I'm sure, but it just creates such uncertainty and risk. And I think to some extent, it forces a lot of employers to make decisions that have them choose between doing what they feel is the right thing for the rest of their workforce and for their culture and things of that nature, and avoiding, a potential legal dispute with an employee who is misbehaving in the workplace. And that's just a tough spot to be in for any employer.
Well, we're getting out ahead of our game. Let's give our audience, our friends who are listening in, let's give them a little bit of background. What's going on that gave rise to this case, and what is the change that you I just referred to? Give us some background on this, Rufino.
Sure. So for a long time, the board, there was a string of board cases that solidified the idea that an employee who is engaging in protected concerted activity, so whether that's union activities or making complaints on behalf of a group of employees, whatnot, that employee is protected under Section 7 of the NLRA. if the employee, in engaging in these discussions with management, gets a little heated, maybe curses or is disrespectful to the company or managers, that disrespect or heatedness would not cause the employee to lose the protections of the NLRA. So essentially, an employer could not fire the employee because he or she was being disrespectful in that context. If we go back to just a few years in the General Motors case in 2020, the board essentially overruled a lot of that precedent that set up those standards and said it's not the setting in which the employee was engaging in this misconduct that matters. What matters is the employer's motive for taking corrective action. So if the employer, under the General Motors standard, was if the employer is terminating the employee because of the union activities or the protected activities, that's unlawful. But if the employer is trying to balance out some other interest and says, we can't have employees engaging in conduct that is discriminatory, for example, and that's why we're terminating, well, it's not the protected activity that was the motivation. Now, with the Lion Elastomers case, we're back to that original standard, which was very setting specific. So if the employee is engaging in protected concerted activity, the board says the employee has a lot of leeway in engaging in conduct that may not be respectful. It might actually be misconduct under an employer's policy, but because the setting is protected and the underlying conduct was protected, the employee cannot be disciplined under Section 7 of the NLRA.
Let's get a little more specific so we can even drill further into that context. 2016, the board in Cooper Tire and Rubber took evidence that picketing employees who were discharged had been shouting racist and profane comments at replacement workers. Further, that in Cooper Tire, that those kinds of comments in a different context would routinely result in termination. They don't tolerate racist comments, and most of our clients and friends don't tolerate any threatening comments, and that gives rise to termination. In that case, this was the pre-Trump board, obviously, the Obama board. They said, you got to look at the context. This is the heated discussion that might take place on a picket line. And so we're not going to just say that if this had been the standard without the protected and concerted activity on the picket line, termination would be laid out. We're going to look deeper. We're going to look differently at this than just the same standards you might otherwise apply. Am I sort of getting it right as to what the standard had been, was changed by the General Motors decision, and is sort of returning to?
That is correct. Again, the focus under the Lion Elastomers case is on the setting again, right? So we're not looking at the employer's intent, as good of an intent or good faith belief the employer may have had it was doing the right thing or that it was not violating the law. If the misconduct is occurring in a setting that is protected under Section 7, then the employee does not lose the benefit of those protections.
I can remember conversations we had going back a year and a half. We sort of generally predicted that was one of the problems potentially, if we went back to old standards, that the protections under Title VII might give way to the protections under the National Labor Relations Act, or the protections that we all expect for threatening conduct might give way to the NLRA interpretation of protected concerted activities. Where does that leave employers as they try to wind their way through, how does the context change what we would otherwise do with the well thought out and frankly oftentimes regularly enforced policies that employers have?
Yeah, the board in its decision in Lion Elastomers tried to address that issue, but I don't think the board is being very practical in its approach here. They essentially say, in the context of let's say racist remarks during a picket line, the board says there is no inherent conflict between the protections of Section 7 in that setting and, on the other hand, an employer's duty to maintain a workplace and environment that is free of harassment and not hostile. I just don't think that's the right view from the board. Ultimately, an employer in the real world who does not take action against the employee who's shouting the racist remarks or epithets is probably going to get a claim filed with the EEOC. And so then you do have a scenario where the employer has to say to one employee, I'm sorry, employee, that you feel you were being harassed, but I can't terminate that employee or engage in any sort of corrective action against that employee because he happened to do all of these bad things in the context of a picket line. And then on the other side, they're going to have to tell the board, if they do discipline the employee, we're doing this because we believe you're creating a hostile work environment. And then you have to go down that rabbit hole of essentially admitting that the employee is creating a hostile work environment and finding that line of, where is the lane for the employer where there is no liability on either side of that equation. And that is a very fine line. It's not an impossible one to walk.
Yeah, that's threading the needle quite carefully. Rufino, thank you so much for these insights. What I'd like to do now is pause our recording and return to our next phase when we talk about this impact not only on those who have union representation, but on those who, like most of our clients and most of the private sector employers in the country, do not have union representation, and learn a little bit more about how this new ruling by the National Labor Relations Board affects them. So let's go cut off here and run into part 2 in another week or so. Rufino, thanks again so much, and we'll be with you shortly. Take care, friends. Thanks for joining us on the Labor Law Insider.